everyone. Welcome back to the Divorce Unplugged podcast. I'm your co-host, Nicole Cox, and from socials, you might know me as the Family Law Liaison.
Hey everybody, Keegan Burke. I am known probably as Divorceology in all of your socials. I'll start with my disclaimer before you hit yours. Not lawyering. This is not legal advice. This is an open conversation and here to get into it with Nicole.
Yes. All right, everyone. I am an attorney, but I'm not your attorney. I'm licensed, but I'm not giving any legal advice today. We are just talking open and raw conversation.
So today's conversation is going to be somewhat complex, but we're going to start on the bill that has been rolling through the California legislature, and that is AB 495, otherwise known as the Family Preparedness Act, and all of the things that we absolutely hate about it, and then how it plays a role in your custody and divorce life as it applies to managing your situation in the best way possible. So let's jump into AB 495, what it says, what it means, and what the risks are from our perspective. And we'll get right into it.
Yeah, and I think it's important to say, even though it's only California at risk at this point, if it gets passed in California, we could be looking at it, bleeding through several other states.
Absolutely. California, New York, some of the big states who roll out with these new bills are kind of the precipice for other states to adopt the same kind of moniker or the same policies associated with these types of things. So, just in general, what jumps out to you as it relates to why AB 495 is something that every Californian parent should be voting against?
Right. So I think it actually dilutes a parent's rights. First of all, the custodial parent. I think it's very scary. I think that if you look deeply into it, first blush, it looks like it's just a helpful bill to help children that don't have parents around, possibly looking at people being deployed, immigration scenarios. But when you really get deep into it, it's literally giving kidnappers and child traffickers and maybe people that don't have custody, basic custody of your children.
Yeah, and so here's kind of the rough estimation of basically what the bill says. Now, the motivation behind it may not be what the bill is actually going to or could actually do, but
Right.
the bill allows any non-related adult, a neighbor, a teacher, an ex-relative, or even a complete stranger to
Mm.
take custody of your child without your knowledge as a parent or your consent. No background check, no court order, no parent's signature, just a piece of paper known as an affidavit. And that to me is one of the most dangerous considerations I have seen as a parent, given how easily my knowledge, my parental rights can be removed by somebody just knowing a few bits of information and putting it down on an affidavit.
Frightening. Yeah, it's horrifying. It's a parent's worst nightmare, really.
Yeah. So, what is that like? Let's just kind of dig into really what that means when we talk about how somebody can pull your children from your life without you knowing. Let's just walk through an example, right?
Yeah.
If you are in a custodial situation, or even if you're not, for families who are together, right? If a
Right. It could be
nosy
anything.
neighbor knows your kid's name, knows where they go to school, knows basic information, all they have to do is put that on an affidavit. They can submit it to whoever has the child and they can remove the child and go wherever they want. Now,
Mhm.
and the motivation might be that if the parent is indisposed or unavailable, that person might have a protected mindset. But for the parent who isn't indisposed and is available and should have rights to make those types of decisions, they're losing it without any court interference, without any due process, without any underwriting of whether that person should have the child.
Not even a notary. And usually on an affidavit, a notary is required. So that's even scary.
100%. Now, we talked about it yesterday in preparing for this conversation. And what I felt like this jumped out to me was not only is it a risk to the families who are going through divorce and custody. For
Mhm.
instance, let's say a parent doesn't have custody. Maybe they're living out of state. they can show up pretty easily. They know all the key information. They fill out the affidavit. They take your kid from school. The problem with that is typically they're going to have a jump start at taking your kid to an unknown place. You're not even going to know the kid is gone because you're not participating in the decision to release them.
Here's what's mind blowing. So you go to school to pick up your child, and then they tell you, well, somebody walked up with a piece of paper, said you weren't going to be available today, took them out of school. Then you have to contact the authorities, the police, and everybody. And that person has a 3 hour jump time to take the child wherever is unknown before you even get involved with police, authorities,
Yeah.
etc.
Yeah, and depending on where you are in, let's say if it's California in this example, if you're not far from the border, you're in another state in a matter of minutes,
Right.
certainly in a matter of hours. So super dangerous. But it also kind of comes back to our prior conversations around the racket of family court and the participants, the professionals or the experts who are part of the system. And what I mean by that is, let's talk CPS for a second,
Oh,
right? How un how little jurisdiction CPS actually has, at least at the beginning or the onset of their participation in your case. But you could argue that this bill is a means to provide folks like CPS workers, 730 evaluators,
oh,
reintegration therapists more
guardian
power,
items,
more
guardian items.
jurisdiction.
Take. Hmm.
Yeah, guardian ad litems, all of the above, to just write down, maybe they've sided with one parent or another, maybe they're paid to side with one parent or another, the whole racketeering element of it. But ultimately, if CPS says, well, there's a claim of violence or a claim of abuse, which needs to be investigated, right? Generally speaking, they can basically leverage this bill as a means to take your child without you knowing.
Mhm. And it's very scary. Yes,
Yeah,
absolutely.
in my mind, it's
So
the
we're
worst
talking
bill.
yeah, it is absolutely it's so bad. So we're talking even like foster parents could come in and a guardian litem. I mean, literally in that list of the people that qualify, it's hundreds and thousands of people. Like we said, a neighbor, it could be a teacher. I mean, anybody that doesn't even have to be related to the child. So it's very scary.
Yeah, it absolutely is, and I think it's one of those things that also starts to bring us back to the thought process around these professionals who are or become involved in your case, and how to very carefully and cautiously make decisions on whether you support, advocate for it, or whether you oppose and object to it. um, because we've talked about it before, right?
Yeah.
It's not to say that abuse and CPS and guardian ad litems and or certain professionals don't need to be involved in some cases, because sure, there are cases that they do.
Yeah.
However, I think they are all too frequently involved, and they are all too frequently given far greater power and decision making and influence over your children's life than they should.
So here's an interesting question for you, Keegan, because we've talked about this a little bit, but it does beg the question, how do you coach your clients when CPS gets involved?
Good question. So there's two sides to that answer, right? The first side
Mhm.
is, let's answer the first question, and that is, if CPS has been called on me, right? If there is an allegation of abuse, then certainly I want to make sure that the proper evidence and the proper information is provided to ensure that that false allegation is found unsubstantiated or unfounded, right? False.
Right.
And so I'm going to participate to the extent that I need to. Uh, Now, in that process, right, let's say CPS shows up at my door and they want to enter my home. They're not entering my home without a warrant, without a court order. They're not going to, come in and explore my residence without the right to do so. I am
Mhm.
going to cooperate in to the capacity that I need to, but I also am going to. This is one of those situations where I think counsel becomes very important to make sure that I am managing my rights as a parent and as an individual properly. So the first call is probably to an attorney to walk through
Mm.
what allegations have been brought to me, what my next steps need to be, and to ensure that I'm following the steps properly to avoid having a negative finding. But at the same time, I'm not, lifting up the kimono and giving them access to things that they don't generally have access or jurisdiction to.
Right. I think that when I coach my clients, it's a double-edged sword. Now I've seen several cases where CPS always pretty much comes up unsubstantiated, literally. And even in situations where I feel like there is abuse happening from the other side, but it comes up unsubstantiated. So sometimes then I think about it and I say to myself, do I really want my clients to even open this case, right? Because
Right.
obviously we don't ever want to encourage any type of retaliatory calls to CPS or any type of child protective services in any state. Um, so because it can actually turn against you. Um,
100%. And to that point, in California, for example, there's a very real risk of making a mistake of trying to leverage CPS if you don't have really good grounds to call them and you don't feel like there's really good evidence that they're going to come out with a finding that there is abuse and or danger or harm to your child.
right.
There's a risk that you're viewed as a false alleger, right?
Yes.
Yeah, I just made up that word.
Yes, a ledger. Okay, so it's a good word. So we'll use it once in a while. But I had a case in Oregon and I was coaching her and the child had a concussion on father's time. And we made CPS reports. They came out undifferentiated. And unfortunately, she went to court and looked like she was, basically trying to push the issue and looked worse in the judge's eyes than the actual perpetrator.
Yeah, and that's kind of the second part of your question from a coaching, clients to how to manage and handle that, right? And I talk about it on one of my posts on my social, and that is really making sure that you are, like I said, deliberate. It's very black and white.
Right.
You feel like the evidence is there's a preponderance of it, right? It's going to be a no brainer. Now, I say that because it's really easy to think that CPS is your friend. It's really easy to think that they're going to come to your aid. It's really easy to just make a phone call. And let me give you an example of that, right? There are times where I know folks have made phone calls, not necessarily to open a report or to make an allegation, but they just don't know. Like, what is the standard? What is the bar? And I would say that it's hard to know, to your point, right? Because there is abuse that is not found as abuse, and there is abuse that, or is an abuse that's found as abuse. So it's like, it's an always moving target. It's circumstantial at the time. But if you call CPS just to ask a question in California, they're going to open the case and investigate it. Now, think twice before you make that phone call and ask. Do some due diligence. That's what Google's good for. That's what, places for you to seek counsel or coaching around, hey, what's going on? Is this really abuse? Now, the only point I would make around the CPS kind of findings is, remember, the courts, these professionals, when they see harm and danger and or abuse, we're talking kids with cigarettes being put out on their legs, living in, squalor. They see some really insane things, and it's really easy for us as parents to get caught up in our case and the emotions of the situation and go, I disagree with that. That's really bad. The parents yelling at them or scolding them or disciplining them in a way that I wouldn't.
Hmm.
And now I want to look for leverage in my case. And I think that's a really bad look. And I think it's really dangerous to do. So that's the only sliver of defense I'll give CPS is the stuff that they see day in and day out. Are there things that we as normal human beings don't generally imagine possible to happen to kids?
Right. Exactly. So the threshold is really high for them
It
to
is.
want to come in and take a child out. But I will caution on this. I have a client in California And she felt like the CPS person was the service worker was really sweet, and maybe her friend let her into the home. And in doing so, ended up sharing way more than she should have with her when all she needed to do was shut the door, guys, and say, you know what? I have counsel and I'll get back to you. Because
Mhm.
the child wasn't even in the home when she came to visit, right? So
Right.
it can backfire on you because even if your other co-parent person, X, is the one that had the call on them, they're still going to come into your house and look, and then they still might even dig into your life and try to find something wrong with you, even though you're not the one that had the report. You see what I'm saying?
100%. Yeah, I have somebody who, you know, CPS was called on them, and along the way in the investigation, what they realized was that the person who made the phone call was actually the perpetrator,
Yeah,
and the investigator opened a case against the caller.
right.
And so it is like that moving target thing that is just really dangerous. The other thing I would say, and I just recently saw a scenario of this, and I think it happens all the time, and we've talked about it actually before, and that's the whole third party care, reunification camps, and the system that strips parents from their kids
Right.
is a parent who didn't have custody, continuously called CPS, never got anywhere, went in
Mhm.
on an ex party motion, got somewhere on ex party, but as they get to hearings and as they start to proffer evidence, the court and the people involved are starting to realize that, hey, this ex parte application probably shouldn't have gone the way it did.
Mhm.
And now the court is stating we need to consider third party care.
Where do you put the child then? Which is
Right.
exactly the situation I found my client in about 2 weeks ago when we were doing a lot of work, with rehabilitation and things, and she was doing a great job, but then she started talking about the other parent. And now we have CPS looking into both of them to see are either one of them actually fit. Now where does the baby go? And
Right.
it's a 1.5-year-old. And then
Well,
the other thing I always say is on visitations, if there's a question and you have an ex that's retaliatory and constantly calls CPS, take pictures of your child after every parenting visit before you drop them off.
yes, absolutely. And again, those are difficult things to do because the
You
opposing
don't want them
side
to
can
know.
argue, right? Oh, well, I'm putting the kid through the process of pictures. And so there are some mechanics around that certainly we would coach our clients through.
Right.
But to that whole stripping the parents away, right? If you think back to what I said at the beginning around AB 495, if the general policymakers of the state are anybody can take their kid, you're only going to embolden the court system that already does it anyway to do it even more, right? Because now it's that much easier to pull a kid from a parent, put them in third party care programming. And by the way, all of this runs around economics, right? Subsidies, funding. If there's a loaded parent in the equation, they're going to pay for the gals, they're going to pay for the professionals, they're going to pay for the involvement of these people. You're
Yes.
going to have to, and these people don't just come in and leave. Once they're
No, you
in,
can't get them out of your case, you can't get them out of your life.
they're hooked to your case. It's an absolute disaster zone as far as I'm concerned. And by the way, I think in a lot of situations, it's really unnecessary if the two parents can put their head on straight and realize that, hey, this isn't about you or I disagreeing on something. This is about what the kids need. And okay, we're going to disagree, but the kids should be with both of us, and we should be working towards a plan, a parenting timeshare schedule that makes sense for the kid
Right.
or kids.
Well, the best interest. And just to be clear, I'm not saying that you should, forcefully take pictures of children that are old enough to understand what's going on. I was actually talking in general about a baby. It was
Totally.
a 1-year-old, right? You can do that, but also when your children get older, you can just have them take a little family picture before they leave the house. Anything, just a little snapshot showing that they're healthy and great and in good care.
Yeah, I agree, and by the way, I would also go so far as, you know, over communicating on some things, right?
Right.
Listen, if you've got a 2 to 1 1-year-old walking, right? So a 1 to 10-year-old, a teenager, kids are hopefully super active. They're involved in
And they get
sports. If you've got an active family, you're doing all kinds of things. They're falling down, they're skinning their toes, their knees, their legs, they're bumping their head. I If you have a child in your care and they get injured, it doesn't hurt to say, "Hey, mom, hey, dad, so and so bumped their leg on the bike and wanted you to know that this happened." You're sort of blunting the edge in the argument that that happened because mom or dad beat the crap out of them, right?
or wasn't paying attention or all
Mhm.
those things. And, I really encourage all of my clients, which is an interesting subject that you just brought up. We do journals back and forth so that at the end of the parenting time, there's a journal that says so and so, child might have been biking and fell off, and there's a scrape on the knee, and this is how we've been taking care of it. And this is what you can do, to help with the healing process moving forward. But it's always like you said, the over communicating. Okay, yeah, somebody did fall or something did happen at school on my parenting time.
Yeah, and there are lots of critics that might say that's a CYA move, right? It's
Oh,
disingenuous, and I would say maybe, but it's
right.
ultimately good for the kid because hopefully it's avoiding unnecessary conflict or false allegations of one parent or the other. So disingenuous or not, there's a benefit to doing it.
Right. Right. And we'd like to say if it wasn't, if it's disingenuous and it really didn't happen that way, that at some point it's going to come out,
Mhm.
you know. But I mean, for the most part, like you said, children have accidents and it's
Yeah,
fair and it happens on a really good parent's parenting time.
100%.
Yeah.
So, in closing on this particular topic, one thing I did get a notice on my phone this afternoon. AB 495 may be hitting some headwinds, which, and as a Californian, that is a great thing. It's being pushed into a basically a finance committee, and some would argue that that's a committee where bills go to die. I would say because the bill is so scary, until it's dead, it's not, right? So it could sit there for years and never come out of there, or it could still see the light of day. But at least for now, it's not moving forward yet. They are, I believe, scheduled to hear the matter and kind of do an analysis of it. But it has, or it should have, a lot of headwinds, right? From a purely legal perspective, then from an application perspective, right? I mean, think about how a school is going to manage something like this if an affidavit really is enough for a non parent stranger to come take your kid from the school. Schools
Well,
have policies in place.
right. So then let's ask the question because we both know with our clients and experience that you have to put a court order into the school and show them who has parenting time when. And if you have 100% legal and physical custody, that other parent can't come onto the school campus at certain days, times, whatnot. So, but with this affidavit, it would allow somebody to supersede, from what I can see, an actual court order, which is very, very scary.
Yeah. So for now, we'll keep everybody updated, but for now it's on ice.
Right.
We'll see where it goes, but we're all here praying to God that it stays on ice.
Yes, we are.
So, in closing, final thoughts from me are be very conscious of who you get involved in your case. Be very diligent about how you handle those that get involved in your case. You don't want to stonewall or be problematic, to the cause, but you do want to be sensitive to the fact that all of these people that you get involved are potentially risky to you, risky to your situation, risky to your kids, and in some instances, necessary. So it really just depends. I think it does come back to what we say every time, and that's exactly why you need a coach, probably why you need at least an attorney that you can call. If not, you don't have them retained. But you want to have a very clear mind around how you're going to handle these types of situations because I find they happen way more frequently to those that don't expect it to. So expect it to. Understand how you're going to handle it, understand what you're going to do, and act accordingly.
Yeah, I mean, I agree with you, Keegan. The the actual reality is that you don't expect it, but all of a sudden CPS can be at your door. So know your rights. Don't let them in and don't think that they're your friend, but at the same time, they are still necessary to help many kiddos get out of bad situations. So we're not saying that it's a bad thing. We're saying just to be cautious what you share with third parties and how much you let them in. Have a coach and definitely talk to your attorney.
Yeah.
Yeah,
So, like, follow, subscribe, share, do all the things. Glad to have you all here and looking forward to our next conversation.
absolutely. Thank you guys, and we'll see you soon.